All right, let's do this. Welcome to a high-speed, no-fluff review of one of the biggest topics for the bar, torts and negligence. Whether you're in full-on cram mode or just need a solid refresher, we're going to build this thing from the ground up, piece by piece. Okay, let's get right into it. So let's start with a scenario we can all imagine. You're stopped at a red light, and then, bam, someone rear-ends you. Your car's busted. What do? What's the legal angle here? I mean, it's not really a crime, right? Though, sure, reckless driving could be a criminal charge, and you definitely didn't have a contract with the other driver that said, hey, don't hit my car. This whole situation falls into that super important category of something else, and that something else is a quasi-delict, and trust me, understanding this is the key that unlocks the entire world of torts. So what in the world is this something else? Well, in a civil law system like the Philippines, we call it a quasi-delict. If you're in a common law country, you'll hear the word tort. Honestly, they're pretty much the same thing. It all boils down to a civil wrong that causes someone else to suffer some kind of loss or harm. This concept right here is the absolute foundation for everything else we're going to talk about today. Let's look at the official language from Article 2176 of the Civil Code. It's so simple but incredibly powerful. It says, whoever by act or omission, so someone either did something or failed to do something they should have, this caused damage to another person. And this is the crucial part. There was fault or negligence. If you've got those ingredients, the law says the person who is at fault has to pay up. Simple as that. Okay, so let's turn that into a checklist for any case you're breaking down. You absolutely have to prove these three things. Number one, actual damage. If there's no harm, there's no foul. It's that simple. Number two, fault or negligence. This is the big one we're going to spend a lot of time on. And number three, a direct causal link. You've got to show that the defendant's specific screw-up is what directly led to the plaintiff's damage. You need all three, or the whole case falls apart. Now, one of the best ways to really get what a tort is to understand what it is not. Think of this section as building the scaffolding around the main idea. How is this private wrong different from a public wrong, like a crime, or different from a broken promise, like a breach of contract? Let's clear that up right now. This chart just lays it out perfectly. A tort, what we call culpa aquiliana, is all about protecting a private interest, like your right not to have your car turned into a crumpled piece of metal. A crime, or a delict, protects a public interest, society's need for everyone to be safe on the roads. The goal of a tort case? Reparation, making you whole again. The goal of a criminal case? Punishment. And that difference changes everything, especially the burden of proof. For a tort, you just need a preponderance of evidence. Basically, is it more likely than not? But for a crime, the state has to prove it beyond a reasonable doubt. That's a much, much higher bar. And this quote right here from the landmark case Barreto v. Garcia just hammers that point home. It says that even if a driver gets acquitted in their criminal case, a totally separate civil action for quasi-delict can still go forward and succeed. This was made even clearer in Elcano v. Hill, which said an acquittal in a criminal case because of reasonable doubt doesn't stop you from winning a civil case that only needs a preponderance of evidence. You got to see them as two completely separate lanes on the legal highway. They have different rules and they're headed to different destinations. Okay, now let's stack up a tort against a breach of contract, or culpa contractual. As the case of Cangover Manila Railroad pointed out, the huge difference is the pre-existing relationship. In a tort, there's no prior connection. The negligence itself creates the obligation to pay. But in a contract, the obligation is already there. You had a deal, and the negligence is what breaks that deal. This is such a critical distinction. A really great case to see how these can overlap is Air France versus Carrascoso. A guy had a first-class ticket but was rudely kicked out of his seat. The court said, yeah, that's a breach of the contract of carriage, but the way they did it so disrespectfully was also a separate quasi-delict. He could sue for both. So, we've been throwing this term fault or negligence around a lot, but what does it actually mean? How does a judge or jury decide if what someone did or didn't do was negligent? This question is the absolute heart and soul of most torts cases. The classic test, the one you absolutely need to know, comes from Picard v. Smith. You might remember the facts. A guy on a horse on the wrong side of a bridge with a car coming at him. The court posed this question. What would a reasonable, ordinarily prudent person have done in that exact situation? See, it's not a subjective test of what the defendant thought was okay. It's an objective standard based on this hypothetical, reasonable person. And the key idea here is foresight. A reasonable person can foresee that their actions might cause harm, and so they act to avoid it. But here's where it gets interesting. This reasonable person isn't some one-size-fits-all idea.
The standard of care we expect from someone actually changes. It adjusts based on their skills, their age, and what they're doing. The law is smart enough to know that context matters. A lot. Let's kick things off with the pros. The law is very clear on this. If you hold yourself out as having special skills, a doctor doing surgery, an engineer designing a building, a lawyer giving legal advice, we can't judge you by the same standard as some random person on the street. The reasonable person standard gets a serious professional upgrade. So we don't ask what an ordinary person would do. We ask, what would a reasonably prudent doctor do? Or a reasonably prudent accountant? Cases like Cruz v. CA and Garcia v. Salvador show that these professionals are held to the standard of their peers. They have to have and use the special knowledge and skill that their profession demands. A simple mistake that an ordinary person might make could be considered serious negligence for an expert.
All right, let's swing to the total opposite end of the spectrum. Children. How does the law handle the negligence of a kid? Well, as you can imagine, the standard here is super sensitive to the situation. For older kids, the case of Taylor v. Manila Electric tells us we have to look at the child's own individual maturity and capacity. But for very young children, the law draws a really firm line in the sand. Citing the Jargo marketing case, a child under 9 years old is conclusively, and that word means no exceptions, no arguments, presumed to be incapable of negligence. A really tragic case that shows how this works for older kids is Yalarde v. Aquino. A 10-year-old student was killed by a concrete block his teacher had left unattended. The court still considered the boy's age, but ultimately found the teacher was the one liable because he should have known the danger it posed to his curious students. It's a reminder that even when a kid can be negligent, the duty of adults to keep them safe is huge. And finally, we get to the highest standard of all. This is reserved for industries that are just packed with public interest. For these guys, the standard isn't just reasonable care. It is extraordinary diligence. You see this in cases like Consolidated Bank for the banking industry, and it's right there in Article 1755 for common carriers like buses and airlines. They have to show the utmost diligence of very cautious persons. And this isn't just for banks and buses. Look at Mercury Drug v. De Leon. A pharmacy misread a prescription and the customer died. The court said, look, dispensing medicine is a business of public consequence. It demands the highest degree of care. Okay, you've got the foundation, you've got the scaffolding, and you've got the core ideas down. Now, let's see if you can put it all together. It is time for a recitation lightning round. 5 questions, 5 key doctrines. You ready? Let's go. First question up. In Barreto, why could they sue the employer directly? The answer. It's because an employer's liability in a quasi-delict is primary and direct. It's not just a backup to the employee's criminal case. The lawsuit is based on the employer's own presumed negligence in either hiring or supervising that employee, which falls under Article 2180. It's a completely separate cause of action. Question number 2. So Kingo jumps off a moving train. Seems pretty risky. Why wasn't that considered his fault? Because the court was looking for the proximate cause. What was the one thing that in a natural sequence of events directly produced the injury? It wasn't him stepping off the train. It was the railroad's negligence in leaving a bunch of watermelon sacks on a dark platform. That was the unforeseen hazard that actually caused him to get hurt. Question 3. Back to the horse and the car on the bridge. You could argue both guys were being a little bit negligent. So who ends up paying? This case gives us the famous doctrine of last clear chance. The person who had the final opportunity to avoid the accident but didn't take it is the one who's held liable. Smith, the driver, saw Pickard and his horse way ahead of time. He could have stopped, he could have swerved, but he didn't. He had the last clear chance to prevent the whole thing. Fourth question. An 8-year-old kid gets hurt in a department store. Can the store try to argue that the kid was also at fault? The answer is a hard, absolute no. Don't forget that rule. A child under 9 years of age is conclusively presumed to be incapable of contributory negligence, period. The fault is 100% on the store for having a dangerous condition. And our last question. Why the super high standard for places like banks and bus companies? Why isn't just being a good father of a family enough for them? It's because their business is what we call imbued with public interest. The safety of passengers, the security of people's life savings. These things are paramount. The law slaps this highest standard on them to protect the public and make sure we can have the utmost trust and safety in these critical services. So, how'd you do on the lightning round? We went from a simple fender bender all the way to the complex standards of care for doctors and kids, and you can see just how deep this topic gets. If there's one thing to take away, it's that in torts, context is king. The devil
And honestly, your path to passing the bar is always hidden in these little details, so keep 'em sharp.